real time.
All right, nice. All right, well, good morning, everybody. And so I'm Nicole. I'm using Joe's account if you're confused where this voice is coming from. Um, so I have a quick intro that I'm going to give to everybody before we start. And I was just talking to Jason about any intros you guys want to include. But so I think we're just going to start around like 10:02. Wait for everybody to log in.
Sure thing.
Rob, can you hear me now?
I can hear you now. It looks like you're coming through the laptop mic. Your headset might be having problems. So you have plenty of time, Joe, if you want to
Yeah,
test it
I've
out.
gone out to USB. Yeah, I'll go out and come in again.
Good morning, everyone. Hey, this is Nicole Rivetto. I'm using Joseph Rabace's account. If you don't see my name listed in the attendees, and I'd like to introduce our Spirion GDPR webinar. I'm going to give another minute or so before I begin, just to make sure that we have enough attendance to join us. So just wait one more minute. Good morning, everyone. Thank you for taking the time out of your schedule to join us for our Vandis monthly webinar series. Joining us today from Spirion is Jason Abbott, manages channel sales with Vandis, Joe Peden, who works in EMEA Sales Director, Rob Server, who's Senior Solutions Architect. Before we begin, I would like to note that all of Vandis's upcoming events can be found on our website under the events page. Please make sure to check regularly as we are continually adding new events in the tri-state area as well as upstate New York. Also, if you are in a noisy environment and using your computer's microphone, can you please make sure that it is on mute so the background noise will be eliminated. If you have any questions, please feel free to ask them at any time or type it into the message window. With that being said, I would like to now turn the presentation over to Rob to begin the webinar.
Thank you. All right. This is the Foundations of Successful GDPR Compliance. I'm Rob Server, Senior Solutions Architect with Spirion. Joining me is Joe Peden, our EMEA Sales Director. And we have a lot of experience with dealing with EU customers who are, of course, required to comply with GDPR compliance that is coming up in the end of May. A little bit about Spirion. We'll go through that now, and then we'll cover a little bit about GDPR and data mapping and protection by design, and we'll also touch on individual rights, including the really well-known right to be forgotten, and then we'll have a Q&A section at the end. Well, why do customers want to work with Spirion? Our main core competency is returning high quality, low false positive data matches. So when we're searching for things, we do a really good job of validating those elements that you want to return. So when you're looking for PCI or banking data, we do a very good job of finding that information and reducing your exposure by up to 98%. We do a really good job of finding and validating those data types. So you can have confidence when you make business decisions on those data discovery and classification projects. And we're a proactive solution. We don't want to react to potential data breaches. We want to prevent the data breach from happening. And in our cases, that happens because you've removed the data from the location and added proper controls around that location. Now, in the GDPR sense, you'll see later that we do a very good job of helping with what's known as Article 30. Now on this slide, you can see we are an award-winning product through Gartner Cool Vendors and SE Awards, and I'll let the rest of the slides speak for themselves. All right, so as a review, Spirion is an automatic and accurate data discovery and classification mechanism. We connect to many different locations. We're able to look in unstructured, cloud, on-premise locations. We're also able to automatically apply classifications to those locations. So what that means is, with the confidence you get from our good quality matches, you're able to apply business rules, the rules you already know that are governing the data that you need to find automatically based on a rule set inside our system. It's also very easy to use. There's no coding involved. It's all menu and GUI driven. And the results of those searches and the classifications are, of course, visual classifications with tagged files, classified locations. We can report on all those locations through our interface called Spyglass. And we're able to see, of course, items for people that have access to data and when that data was created, for example. We're also able to integrate with other solutions like DLP, McAfee, Splunk, through multiple mechanisms inside the solution. So we're able to get those data elements to the controls you need outside of doing that data discovery and that automatic classification. All right, so let's step through a GDPR overview. General Data Protection Regulation, the GDPR, has actually been in development since summer 2012. It was adopted by the EU in April of 2016, and it's in effect on the end of May this year. It replaces the EU Data Protection Directive from 1995, and it's a beast. It's a large regulation. It's 99 articles and 173 recitals. There's a lot to it, but we'll break it down here so it's easy to understand. The most important part here is that it is a regulation. It's not a directive. It can be enforced by law. All right, what is the scope of GDPR? I guess the first question most people ask is, am I affected by this? And, well, you need to ask yourself some questions. Do you control personal data for commercial reasons? If this is personal use, that's out of scope. So, PCI data, banking data, health-related information, intellectual property, if that's for a commercial business, you may potentially be in scope. Well, do you control or process data? That second bullet point means not only are you first party, however, if you are second or third party and hold that data that is for commercial reasons, you may be in scope as well. So this means associated organizations, companies that process data for you, they may be involved with GDPR compliance as well. The organization needs to prove that systems that collect PI data are compliant and are not supposed to collect PI, are verified as not collecting or storing that. So this is a very stringent rule here in the middle of the page here. You have to demonstrate that you don't have that data. It must be validated. Now, a data processor, as I said, is someone that is under the instruction of a controller, a cloud provider or an HR payroll provider, cardholder data processors. They all hold data which may be included in GDPR regulation. Next question, are your data subjects EU citizens? GDPR broadens that territorial scope. So what this means is if you're involved with an EU person and you have that data, then you are going to be involved with the GDPR regulation and compliance regulation. So it applies to all organizations that have offices in Europe, companies that simply sell or market into Europe, and it's also used by countries as a benchmark to template their own data protection laws. So this is going to be used as a model outside of Europe in the future. Another consideration, is the data personal? And if so, how personal? GDPR applies to all types of data, and the consequences of failing to comply varies based on the type of personal data involved. So you may be concerned, of course, with PCI and PII data, but there's many other types of data such as genetic, biometric, IMEI identifiers, GPS coordinates, even browser cookies can be included in scope for GDPR compliance. Last question here you need to ask yourself for GDPR consideration. Is the data anonymized? So those things such as IP addresses or cookie identifiers or the genetic or biometric information, if you cannot tie them back to a user, and when we're talking about pseudo-anonymized or anonymized, that means there is no link back to the original type, then you're okay. So you have to be able to anonymize data that you hold to be compliant with GDPR. So what happens? GDPR administrative fines, many people have heard that this is going to be within up to 4% of annual global revenue or 20 million euros, whichever is higher. And I may ask Joe to come in here and give his thoughts on this, but basically it's not necessarily the fines, it's the brand damage, reputational damage you may suffer through having a penalty through GDPR. You may also be subject to being able to restrict processing data. That means if you are a data processor for a European company, you may be blocked from accessing that type of data.
Guys, Rob was absolutely correct. One of the things a lot of European companies complained about was that the regulators weren't giving them precise directions as to how to be compliant with GDPR. And when you read the regulation, it becomes clear that the regulator cannot do that. Your compliance with GDPR is driven by your own data privacy notices. There's specific reference to data privacy notices, or DPNs. And those are your public statements as an organization as to how you're going to collect data, how you're going to manage that data, how you're going to protect that data, who you're going to share that data with. In other words, your good data governance rules. And GDPR under Article 84 stipulates that if you're not compliant, you will be subject to a 4% fine. But in reality, it's more likely to be Article 82, where there outlines specific non-conformances, and the fine would most likely be a 2% fine. But I keep discussing this with clients. That's what consultants all across Europe are talking about, 4% fines. The reality is that when the auditor comes on site, they will look to see, have you done what is known as a DPIA, a data privacy impact assessment. And that data privacy impact assessment is an audit against your own DPN, your own data governance rules. And it is a measure of how well you are conforming with your own publicly stated policies for good data governance. And therefore, you have to be able to show the regulator what actions you have taken over what period of time to protect the data subject data, and more importantly to the board of any organization, is what actions you have taken to protect the brand, because the damage that a data breach can do to a brand that you've invested millions in developing over the years can sometimes be non-recoverable. And that is one of the big challenges for companies moving forward. What have you done to protect the brand? So everything under GDPR will start with the company's own internal data privacy notices. And it's actually fascinating to understand when we talk to companies across Europe and across the globe, because as Rob said, any company that sells or markets into Europe must be compliant with GDPR. How many of them do not realize that they have to get the data privacy notice compliance demonstrable, and to do that you have to be compliant with Article 30. You have to be able to generate a sensitive data inventory and map.
Yes.
Anybody in the call have any questions at this time before we continue on? Rob?
All right. Thanks, Joe. One thing we want to include on this is that the regulation it does empower groups to file U.S.-style class action lawsuits en masse on organizations that are damaged. That's in addition to the brand reputation, of course. And the claims are customers who choose to claim against a data controller or processor in the event of a data breach. So that is pretty much the classic U.S.-style class action lawsuit. Now, how do you work within the guidelines of the GDPR? So the first steps are to know what personal data is, and we've described that at a high level that your organization might have. Implement privacy by design. We're going to talk about this a little bit later in the slide deck. Understand Article 30, which is the data mapping. I'd mentioned that at the beginning of the call. This is going to cause you to understand what, when, and where the data that is subject to GDPR, you need to demonstrate that you have controls over that data. GDPR regulation stipulates that you need to hire a data privacy officer to manage data protection and manage the flow of information inside the organization. Joe had mentioned a few moments ago data privacy notices. So this is the ability to demonstrate to a customer or a subject in GDPR terms why you have data, how you're storing it, what the data retention is. And Joe also mentioned the privacy impact assessments. This is the ability to provide that initial step into Article 30 to understand what your footprint is in an organization, to understand what the next steps are. And the last step is, in the event that you do discover that a data breach has occurred, you need to understand that that needs to be presented within 72 hours of discovery. Joe, can you talk a little bit more about the reporting aspects for the 72 hours?
Exactly, Rob. So, guys, one of the things that we have found that is consistent across all the companies that we've spoken to over the past 3 years is I've yet to meet a company that understands where all of their sensitive data is. Now, most companies know where their sensitive data should be. They also have an estimate of where it potentially could be, but no one company that we've met is able to say across both their structured and unstructured data exactly where all the sensitive data exists across their network. So if I do not know at a macro level where sensitive data is located, there is no way that I can get down to data subject levels. There's no way by definition I can ensure compliance with Articles 11 to 22, the individual rights as defined under GDPR. Now, by definition, what that means, I've seen companies try to use, Rob talked about DLP. DLP is a fantastic technology. It helps me manage data in motion when it's copied or printed. I've seen other companies try to use user access controls to control who can see data. But again, I can only set those user access controls when I know the data exists. Another way is to encrypt data. Again, I can only encrypt data when I know it exists. So it's important that when companies look at GDPR, the regulator in the UK says the first step to GDPR compliance is compliance with Article 30, generating this inventory and map of your sensitive data across your entire estate. That by definition means the client has to look at data at rest tools to facilitate the generation of that inventory, because there's simply no way humans can conduct this task across the data volumes that we're looking at. And when you have done that, then we can start thinking about we can report data breaches within the 72 hours, because now I have the granularity to say where Rob's data exists across our infrastructure. Without having that inventory and map, I simply do not know where the sensitive data is. And you could give me 72 months, I simply could not ensure that I would be compliant with that part of the regulations. That's going to come into Articles 30 to 35, working with the regulator's office, cooperating with the regulator's office, and reporting within the stipulated timeframes any potential data breach that may have occurred. Rob?
Thanks, Joe. All right, so let's take a look at GDPR mapping and protection by design. So we talked a little bit about what personal data is, where it should exist, where it shouldn't exist. There's an identifiable person. This is called a data subject. This is the person whose data GDPR is trying to protect. You need to protect that data by anonymizing it or removing it. Any personal data that's been tokenized can fall within the scope of GDPR, depending on how difficult it is to attribute the token to a particular individual. So what that means is, even though you may be containing and protecting personal data, if your tokenization or encryption is reversible, you may still fall under the scope of GDPR. So you need to have a understandable, non-reversible plan of anonymizing that data. Okay, Article 30. This is probably, at least in my opinion, probably the most important part of the GDPR regulation, and that is understanding what the data is in your organization, who the data owner is, why it's there, what the personal type of data is, where it is, how it got there, where it could go, how long it should be there, and security measures around the data. So not only do you need an entrance plan and a management plan for the lifetime of that data, you need to understand how to and demonstrate how to remove that data. And we'll cover that with the individual's rights a little bit later in the regulation. I talked a little bit about data protection by design and default. So while this isn't necessarily something that could be implemented with existing systems and infrastructure, systems going forward are required by the GDPR to implement this, as part of their Article 25. You need to be able to design those systems with the requirements in the previous design in the previous slide in its design. So you need to be able to have that entrance management and exit strategy for data. Also, there's other principles such as data minimization. If you don't need it, get rid of that data. You don't need to hold 12 years worth of data if the regulation says you have to have it for, say, 8. Don't keep data you don't need. It will help you apply to GDPR. I mentioned data protection officers earlier. This is Articles 37, 38, and 39. Organizations will have to appoint a DPO. This is someone who's responsible for understanding the data that's held in an organization, advising, monitoring, and reporting back to organizations at the highest management levels. Privacy notices. I'll ask Joe to help me a little bit here on this one because this is a very important aspect as well. Articles 12, 13, and 14. Privacy notices demonstrate that to subjects why and how you have that data, but also you have to give them an option to opt in or opt out, if I'm correct, Joe.
That's absolutely correct, Rob. And against each data privacy notice, you are expected to have conducted a privacy audit, a DPA. Myself and Rob worked with one of the leading banks in the UK recently, and they actually didn't know how many data privacy notices they had. So again, we used our technology to scan their infrastructure, and we actually found 1,500 different data privacy notices currently in use across the entire organization. That's impossible for that organization to afford moving forward. So their first step in GDPR was to actually set together a project team specifically for the rationalization of the number of data privacy notices they had. And as I said, it's against that you will get audited. And also referring back to Rob's reference to the DPO, the DPO is supposed to be independent of the organization while working for the organization. And the DPO potentially will go to jail should the regulator not be kept informed or GDPR not be proven that you are compliant with it. So it's a very serious task, and it's currently estimated that across Europe there will be a need to require over 28,000 different DPOs for organizations as this regulation comes into effect on May 25th.
Okay. Of interest here, there's one other point. Written in clear and plain language, so that doesn't mean legalese. That must be something that's able to be understood, especially if the DPN is to be addressed to a child. You have to be able to demonstrate clearly to the subject.
Guys, are there any questions so far before we continue?
Yes, there was one question I saw in the chat window, and I believe the question was, we're an auto dealer here in the United States that we do not sell or market into Europe. Am I required to comply with GDPR?
No. GDPR applies to any organization that sells or markets into Europe or retains data about European data subjects. So if you do not have any information on your data systems, that relates to European citizens, and you do not market or sell into the European Union, you do not have to be compliant with GDPR. But understand, South Africa is bringing out its own version of this called POPI. Turkey's bringing out its own version of this called Triple K. In Canada, there's a regulation called PCETA also coming out. So various companies across the world, countries and governments across the world are looking to enforce their own version of GDPR. Historically, GDPR is actually a German regulation. And because it is becoming a gold standard, if you don't have to be specifically compliant with GDPR today, tomorrow you will have to be compliant with some regulation, as all companies strive to adhere to or generate a gold standard for data privacy and security.
Okay, thanks, Joe. That was the only question. I'll move on to the PIA. This is Article 35. So, Joe, you mentioned this was a key portion of the GDPR as well, the privacy impact assessment. So this is the first step to help you comply with data protection obligations. It helps you identify and fix problems at an early stage, reducing associated costs and damage to your reputation, which might otherwise occur. So the GDPR regulator has also mentioned, of course, as enforced privacy by design approach. So I realize this is a rather busy slide. The one thing you need to understand about this slide is that bottom right-hand side. A PIA is not a one-off process, but it needs to be embedded inside your compliance environment. So you can run this process again to demonstrate to GDPR regulators that, yes, you are meeting compliance. And there's 4 steps here we're going to cover in the next slide. A secured approach, understanding your process, accurate execution, enable robust reporting. So you need to understand the data that's flowing through your systems, and trusted compliance. And we'll address these in the next slide. So a secured approach. You need to understand the data types that are expected to be found. This is a mapping process in the beginning that you need to understand what is being collected, what is being held, and get rid of the rest if possible. This also includes identifying locations that should be searched, including the areas that should not store or collect PI, because data tends to crawl into places where it doesn't belong. There's a legal aspect that you need to understand and validate your company's data retention policy, because this will have to be presented to the subjects on request. And understand how to achieve success and report to your senior stakeholders that you're meeting the secured approach. Now, the mastering the process is defining strategies to apply to different systems and infrastructure elements, because it's not one size fit all. I realize that there are many different types of systems. You need to understand how to apply the protection and the remediation process to different organizational elements. Implement those remediation actions, identify your workflows. So the workflows and remediation actions, those are the data elements that help you understand what needs to happen with those sensitive data types, the subject data that needs to be understood. And identify areas where you have gaps. So you may not have an interface to get into the data elements that you need to find. You need to identify that in part 2. All right. So the PIA, under accurate execution, validates all of the things that you've done so far, refines your data classification and workflows, and identifies those areas that contain the collections of data, perhaps in areas that you didn't expect to find them. Those are the honeypots. Those are the things that need to be protected. So you're showing progress when you hit stage 3. And then, of course, report on those elements. Have a dashboard, have some sort of reporting mechanism to the regulator, to your internal board that understands that you can apply those data elements. And of course, trusted compliance. This is allowing you to demonstrate that the PIA is working, and you can present that to subjects, stakeholders, and the regulators. Is there anything I missed there, Joe, that you want to comment on? All right. Let's go ahead and go to the next slide.
Sorry, Rob, I was talking away on mute.
No worries. Go ahead, Joe.
No, again, guys, what we're trying to do is demonstrate there's a granularity here that we need to get into. I've attended many conferences and everybody talks about the 4% fines and everybody talks about conducting a PIA. It's the details. How do I go about this? How do I actually accurately execute on this, and what's it going to involve? And then, as the regulator in the UK says, the first step to GDPR compliance is educating the senior board level members as to what it actually means. You need, as Rob has pointed out here again and again, a compliance is an ongoing process. People think they can simply do a one-off audit and they will be compliant. But companies don't stop generating data, and so compliance is an ongoing process, and you need to make sure that you can put processes in place that are replicable time and time again. Any questions before we go on?
I think we're good, Joe.
Good.
All right, so data breaches must be reported within 72 hours. This is recitals 85 through 89 and articles 33 through 34. So this is a much shorter time frame than in a lot of regulations I've seen, Joe. So in instances, this is looking at point 3, where data breach represents a high risk to the data subjects, the controller also has to notify those individuals. So the time window is one thing. However, demonstrating this and reporting this to the actual individuals themselves is something new I've seen. Now, the controller may exempt if they've taken steps to ensure that the risk of the individual is mitigated. However, the regulator needs to determine that. What can be achieved through application of data protection by design principles. So if you have that privacy by design in place, then you may be able to mitigate this reporting window.
The key here, guys, is, as I described earlier, if you do not know 100% where all of your sensitive data is at a macro level, there is no way when a data subject is breached can you notify a data subject that his information potentially was accessed. And so compliance is really about good data governance. To be compliant with these articles and to ensure that you don't incur fines, you need to get companies going to have to get a much deeper granularity on their handling of their sensitive data, right down to it's Rob's server, it's Jason Abbott, it's Sarah Gerber. I need to be able to say exactly where your information is on my estate and how it was managed. And that is not a trivial task to achieve.
That's right. Okay, so one of the last segments I want to cover here is GDPR individual rights. So consent under GDPR, for example, is requires some form of clear affirmative action. What that means is you cannot assume silence, pre-tick boxes, or inactivity. That won't work. You have to have the person opt in. It's opt-in only for GDPR consent. Now, consent could mean that it needs to be verifiable. So there has to be a record. You cannot tick the box and then allow them to go on. You have to store the record that they applied this affirmative action at a certain time. This doesn't apply, of course, to appropriate children, but do know that it does permit member states to provide a lower age of law as long as it does not fall below 13. So we're trying to protect children here as well. And go ahead, Joe.
So guys, there was a couple of instances here in the UK where the regulator, the Information Commissioner's offices, actually fined 2 companies already for their mismanagement of consent. I won't name them by name, but one was an airline company, and they sent out an email, I'm sure you've been getting a lot of them recently, advising their user base that they, under GDPR, they needed a better and clear management of consent. And they asked all of the customers to update the consent form. They made a mistake at the bottom of the form. They put a link to a marketing quiz where you could win free flights. That was regarded as the ICO's office as spam mail, and so they could, $70,000. Another large consultancy company based in London, again trying to manage consent, sent out an email to all of their user base. They got fined £50,000. The mistake they made, they emailed customers who had already opted out of emails. So again, they're regarded as spam mail. So there's practical challenges here to make sure that the information you have that is current, that you can navigate very, very carefully on.
All right. Thanks, Joe. That's basically what we covered, and I do want to do a time check. We're starting to run a little short on time. So I did want to cover the Article 15 section, Joe, if you want to help me with this one. Everyone knows about right to be forgotten. However, this was not in the original scope for the GDPR regulation. This was introduced in 2014 with the Spain versus Google court case. Individuals have the right to be informed that you are keeping their data, right of access, rectification, so we can break down all of these if there are any questions about them. Rectification is if there are errors, for example. Right of erasure, that is the right to be forgotten. Right to restrict processing. So this is a key element here that goes with the marketing example used a few moments ago, Joe. Restrict processing. If you don't want to be exported as part of a marketing team, they have the right to stop that. That also applies into data portability. You cannot export a subject's data without their consent. And right to object also ties into that. This last point here is right in relation to automated decision-making and profiling. You cannot automate or marketize data without consent.
So again, guys, and I apologize.
Go ahead. Go ahead, Joe.
I'm sorry, I'm just breaking up. Yeah. So again, guys, how companies have tried to avoid, since the Spanish court case, how they tried to avoid actually having to be compliant with this regulation is they've said to their customers, oh, you have to pay a fee of £70 or £50, or you have to submit in writing, and you have to give us 3 months to be able to make those amendments on our system. The reason being, companies simply did not know where the sensitive data was being stored. Now, that is no longer the case. Now, you can no longer charge for facilitating compliance. If I send to Google or Facebook to be forgotten, they have to get my data off their system within 72 hours. If I say I want to see what information they're storing about me to Equifax, have to provide that information for me. If I say I want to move from structured systems and all structured systems and make it available to be exported to my third-party vendor. Again, if you do not have a good data governance and a data subject, it's impossible compliant with. Companies across Europe are petrified as is spurious class action lawsuits taken against them. We have one in Europe where people were forced or missed payment protection when they took out mortgages, and it's cost the financial services industry in the UK $1 billion. Companies are petrified that they'll be subject again to spurious claims, people asking to be removed and having restricted access to compliance within 72 hours. Then that subject would be subject to a class action lawsuit. And it's a major, major concern. In addition to the fines that everyone talks about, this the impact individual could do more damage to the bottom line than an actual fine for non-conformance.
Okay.
Rob?
Thanks, Joe. All right. So data needs to be able to be obtained by the data subject, and this is just a list we can provide to you of what data the user can request. So basically everything that you can contain about them may be requested by them at any time. Individual rights disclosures. And this is a review of the individual's rights we had in a broken out format. So the rectification, complete or inaccurate data, restriction, portability, automated decision making, direct marketing, for example. All right, so in this case, let's go ahead and move forward to next steps. And if you've liked what you heard today, we would like to meet with you. Vandice can have a one-on-one meeting with us, and the ability to discuss GDPR next steps, review your areas of your business you'd like more visibility into, and we'd like to help you solve your problem by conducting a data security assessment. In that case, we'll leave that here and see if there's any questions.
Questions, guys?
Okay, I think that's it, Nicole.
Don't be shy.
Stand by, Joe.
Hey everybody, how you doing? Sorry, I was on mute.
No worries.
Thank you so much. That was very, very informative. Took a lot of notes.
Excellent, no problem. We can make this presentation available. I believe you received a copy from Jason.
No, I have not. If you could send that over to me, that'd be great.
Okay, no problem.
All right, thanks.
All right, so if there's any next steps, just let us know.
Yep, I will probably send you a summary of the presentation, and I'm going to do some video editing and put it onto our YouTube channel.
Okay, super. Thank you so much.
Thank you so much. Have a good day.
Alrighty, bye-bye.
Bye-bye.